Yes, Mr. Das.
My lord, I beg to mention item number 30 and 34, my lord. Item number 30 and 34. These cases are of my friend Vijay Sharma. He expired on 22nd of this month, my lord. I require 3 weeks time to collect the records from his house. 30 and 34.
Mr. Das, we'll initially, these are admission matters, will issue rule.
Yes.
So ask someone to be here on your behalf. We'll pass it.
Okay.
But here, my lord, item 20, I have to verify 2 documents, my lord, from the record, my lord. 1 and 10 I will allow, my lord, if necessary, my
Mr.
lord.
Rathia, let your colleague be here. We'll be issuing rule. Thereafter, you go to that. Okay?
Maybe, Lordship. I beg to mention item number 13 and 14, my lord. A petitioner already expired on 24/8/2022, my lord. And I may be allowed to some time to take instruction from the client, my lord. And already one order already passed, my lord. Directed the petitioner to take steps for improvement, my lord. 13 and 14.
Just a minute. Just a minute. Let our other mentions be here.
Yes,
We'll
yes.
take care of it.
May I please, your lordship. Lordship, I beg to mention item number 16, lordship. Let the matter be adjourned for 3 weeks, lordship. Actually, after expiry of my senior, we have tried to intimate our clients, but we haven't got the consent yet. So let it come up after 4 weeks, lordship.
We'll not keep in the matter for admission. We'll issue rule. In the meantime, you take steps. Hopefully.
Lordship.
May I please,
Obliged,
my
lord.
lord, I beg to mention item number 26, my lord.
Hmm.
In this matter, my lord, the file has been misplaced, my lord. Kindly,
Okay, just a minute. Who are the persons mentioning in the admission column? Whose matters are there in the admission? You need not make any mention for admission matters. We'll pass orders. Whatever the relevant order is required, we'll pass. Don't make any mention for admission items. Anybody? Anybody mentioning which are not in the admission matters? Anybody mentioning? If you're all having admission items, wait for your turn. Wait for your turn.
May it please your lordship. Lordship, I beg to mention item number 47. My senior, Mr. Chinmay Chaudhary, is indisposed for several health issues and on leave. Kindly adjourn the matter for 2 weeks, lordship.
Have you informed the other side?
Yes, my lord.
Whom you have informed?
Mr. P.K. Roy Chaudhary, sir.
I
Opposite party.
appear for the applicant.
Why it has been listed today for orders?
Orders, lordship, there is a delay application here. It has been listed for orders, but since my learned senior is not well, we have no objection.
It is submit the bar that Mr. Chinmay Chaudhary, learned senior counsel appearing for the respondent is indisposed. What's your good name?
J.S. Das.
And Ms. J.S. Das. Assisting Mr. Chaudhary. Praise for some accommodation. To which Mrs. S. Chakraborty, counsel appearing for the petitioner. Have no objection. Prayer allowed. As agreed by the parties, release this matter again on 29th of May. Okay.
Most obliged.
May I please, your
Okay,
lordship,
madam.
I beg to mention item number 7. Kindly
Yes. What's your
Kindly-
prayer, madam?
kindly the matter may be adjourned for the day. My senior is out of station.
What's your good name?
A para, sir.
The prayer of presence. Matter be adjourned for week. Immediate to be fixed. Yes.
So am I praying for an adjournment in item number 3 and 12, your lordship? The engaged counsel is having some personal difficulty, your lordship.
What's your good name?
H. Burag, my lordship.
On behalf of Mr. P. Sundi. Item number 3, 2 and
3 and 12, your lordship.
negative. It would Sundi hit attach basis. For a week, same order. Immediate to be fixed. Yes.
Lordship, I beg to mention item number 5. My senior is out of station. May be listed after some time.
What's your good name?
Kashab De.
PC Dev on behalf of Mr.
May I please your lordship, with regard to item number 35 and 36, Mr. Mishra has been engaged as an amicus curiae in this matter. He is indisposed
Mr. is appearing?
for amicus curiae, my lord, as amicus curiae in the matter.
Yes.
He is indisposed today, my lord. May I pray that the matter may be taken up on 8th or 9th, my lord, of May. Or any later date, man. No,
16th.
16th. All right.
It is submitted that Mr. D.K. Mishra, London Senior Counsel, appearing as an amicus curiae in these matters, are at this post. Mr. P. Shah, Counsel for Counsel. Respondents have noted. 16 as agreed by the parties. Sound 13, 14. Details in it.
Yes. There is a two case, my lord. One was declared from Guwahati, one from Bongaigaon, my lord. Parallelly, two proceedings were going on, my lord. That's why, my lord, subsequent, my lord. On WPC 5644, my lord, challenge the proceeding, my lord.
Mr. Motin,
Yes, there is a order, my lord.
so
There is a order to direct the prisoner to implement. my
we'll
lord.
close it. See, basically, now after more than 1 year, how will you able to file a substitution petition?
Yes, my lord, I may be allowed to some time.
What sometime? Close it.
Actually, my lord, what happened in this case, my lord?
See, basically,
Advocate is provided the copy, this brief, my lord. That's why, my lord, I have no any contact number of the direct petitioner, my lord.
earlier orders are there,
Yes, yes, yes,
November 2022.
yes.
And then the thing is this, if anything is there against
My
the
lord,
children, then definitely the proceeding has to be initiated. Then only they'll be able to say, why at this stage? Automatically it goes, has become infactual.
sometime.
Why sometime? You have, whatever is possible, you have made it.
My lord. Actually, actually, phone number of the petitioner, my lord, in this case, my lord. No phone number is provided, my lord, but advocate who has sent the brief, my lord, his number, my lord. I have communicated him, my lord.
You have given your phone number only. Mr. A. M. Ahmed, Learned Counsel, appearing in both these matters. In November 2022 and March 2023 respectively, submitted that the petitioner expired on 24/08/2022. Though in both the matters, both the cases, the court earlier granted time to the legal representatives of the petitioner to file necessary application for substitution. slash implement of their for substitution, they are implement complete, they are implement. But none has filed any application till date in either of the matters. Mr. Morton, Mr. Ahmed, counsel appearing for the petitioner in both the writ petitions. Prays for some accommodation as he is yet to receive instruction from the legal representatives of the deceased petitioner. Placed on 13th May.
May please, your lordship. Lordship, in this case, lordship, the petitioner declared foreigner 66 to 71 stream, my lord. Notice was issued, my lord.
You are challenging.
Yes, my lord.
You have not yet registered.
Yes, registered, my lord. Already registered.
You have registered. Where?
Yes, my lord. Registered, my lord. Registered 26 2017.
Even now you are challenging the order.
Yes, my lord.
Notice in this case was issued on 12/5/2020. And as wrongly listed for motion today. Matter pertains to the impugned order slash opinion dated 27/03/2017, whereby the Learned Foreigners Tribunal, Borpeta 6th, in FT case number 83/2015, comma, in a reference being made by the Superintendent of Police Border, Borpeta, opined him to be a foreigner under the Foreigners Act 1946. During the period of 01/01/1966 to 25/03/1971. It is to be noted herein that the petitioner has already submitted his application for registration under Section 6A of the Citizenship Act 1955 before the Special Foreigners Regional Registration Officer, Borpeta, on 26/04/2017 in pursuance of the said, in pursuance of the impugned order is the 27/03/2017. Issue rule returnable for it. All for the records of FT case number 83/15 from the Foreigners Tribunal 6th. This matter for the
Obliged, your lord.
hearing allocated. Bail chal. Registration for reply to all for the records. Yes.
Your lordship, I'm on behalf of the petitioner. Petitioner is a mason by profession, your lordship, and he is a permanent resident of the aforesaid address. Senior
Senior Superintendent of Police, Buxa, has made a reference against the petitioner that he is a foreigner who came from Bangladesh and who entered illegally in Assam at 24 March 1971. And the case was registered against the petitioner and FT case number 925 of 2015. And the learned tribunal has declared the petitioner as a foreigner, being not judicious, deserved to be set aside and quashed.
Mr. Payang. On 9th of July 2018, the Foreigners Tribunal, Kamrup Metro 2nd, Guwahati, on a reference being by the Senior Superintendent of Police, Border City, Guwahati at that point of time, appointed a petitioner to be a foreigner. July 2018, there is no order in favor of the petitioner till date, though this petition was filed sometimes in December 2019. Now, will you be able to tell us, representing the Home Department, what is the status of the petitioner? Whether he has been detained in detention camp, or a person declared to be a foreigner is roaming freely? See, you are representing the Home Department.
Yes.
You must have the informations. It's not that you will obtain instruction. You must have the informations in your hand. These are the persons declared to be foreigner by the Foreigners Tribunal. These are the matters against whom there is a stay order passed by the court. And there is no stay order, then what is happening with those foreign nationals? Till date, he is a foreign national.
Yes.
Now, you can imagine July 2018, where end of April 2024. There is no stay by the court. And the Home Department failed in giving you all this information. Only when the court will ask for, that is not the thing. They must have the information promptly.
I will get it, my lord, but I may be given 1 day time, but I will get it tomorrow by tonight.
We have it on Wednesday. Let's come with and you see difficulties, we have less number of persons in the registry.
Yes.
And this matter was listed in 2020 for motion on 13th of May 2020. Thereafter, it has been listed.
Yes.
But that doesn't mean that you will not have the information. Next.
Well, Lordship, only matter of urgent for time being. My senior is coming from another
Item 4.
item.
Notice in this case was issued on 14/05/2020. Matter pertains to the order dated 11/02/2019 passed by the Foreigners Tribunal number 5, Palpara in FT case number FT/5/259/MO/16, whereby the petitioner was declared to be a foreigner under the Foreigners Act 1946. Notice in this case was issued on 14/05/2020. On the said date, the court also granted interim protection to the petitioner, whereby said order of the tribunal dated 11/02/2019 was suspended until further order. issue rule returnable by 6 weeks. The petitioner shall appear before the Superintendent of Police Board Goalpara on or before 17th of May. Call for the records of FT case number F.T.5/259/MO/16 disposed of on 11/02/2019 from the learned foreigners tribal number 5 at Goalpara and shall list the matter for hearing.
Already he has appeared.
There is no direction for appearance.
Doctor,
That is why we have directed to appear before the Superintendent of Police Goalpara on 17th of May. It's subject to parody.
The person to last matter, the notice has been issued in this case, madam. Now we are on interim production.
Parody, Baba.
So we appeared before the SP, madam.
RFP case number 518, capital B oblique 2016. Immune protection, interim bail 15/05/2020. Opinion dated 02/02/2019. Rule Maknevar. Shall not leave liquid with the biometrics. Do by order dated 15/05/2020. Records of said RFP case number 518B/2016 was called for from the foreigners tribal number 5 Kamrup at Songia. The office note reveals that office note dated 24/04/20 as on date. The records of the said FT case record that the registry has not yet received the records of the said FT case from the concerned foreigners tribal. It's a reminder. All right. Copy of this order to Mr. J. Pine.
Obliged, mother.
Failure on the part. The authorities and the postal cost.
Lordship.
Yes, Mr. Sharma.
Actually, Lordship, by 10/5/23, the Honorable Court has directed me to place some material that the proceedings Father Sahed Ali, whose name is in the voter list of 65, is the same Sahed Ali whose name appears in the 85, along with the, but because of certain family constraints, I could not obtain the materials, Lordship, because it is a shifting case. So I pray,
Mr. A.K. Sharma, counsel appearing for the petitioner. The by order dated 30/09/2019 passed by London Foreigners Tribunal number 3rd Morigaon in case number FT within bracket C260/2015. Declared the petitioner to be a foreigner under the Foreigners Act 1946. The court earlier on 27/05/2020 called for the records of said FT case from the Foreigners Tribunal 3rd Morigaon and granted interim protection and interim bail to the petitioner, which is in force till date. In perusal of the office notes, we have seen that on perusal of the office note dated 24/04/20, we have seen that registry is yet to receive the said records from the concerned Foreigners Tribunal. To rule returnable by the so reminder for the 11 records from the concerned Foreigners Tribunal. Failure on the part for ID. Copy of this order to the bank. Shall not need without priority. Place this method for hearing. Records from the concerned Foreigners Tribunal. No representation on behalf of the petitioner on call. Do name of three councils have been reflected in the cause list. On earlier occasions, when this matter was listed for motion, I on 01/06/2020, and 09/03/2023. This writ petition was adjourned on the prayer of the council for the petitioner. Further on 02 and 20 and further on 20/02/2023, the petitioner remained unrepresented. On the said date, i.e. 20/02/2023, the court observed that in the event none appears for the petitioner on a subsequent date, adverse order shall follow. This matter has been listed today for motion after 09/03/2023, though by court on 09/03/2023, directed to release this matter after 2 weeks. Considering the same we consider same release this matter again on 10th for motion.
Madam President, Lord, in this case, Lord, on the your lordship comes to phrase 18, Lord. A petitioner's name was figured in the voter list of 1965. Sorry, 1966. Her name is Rukmini Mollik. Ward number 12, Guwahati, Nutan Bosti. Got it. Rukmini Mollik. Now, my lord, your lordship come to the page 39. Rajendra Putra. Rajendra or Krishna Jagad? No.
Mr. Payeng, this is another matter. It's a devoter's case. Notice was issued by the tribunal, the petitioner, in 2007. She appeared before the tribunal on 18th of December 2007. Short time to file her written statement, which she never filed. And ultimately, the tribunal on 19th of December 2011 declared her to be a foreigner, as she failed to prove her nationality as required under Section 9 of the Foreign Affairs. Now, petitioner filed this writ petition on 28th of February 2020. So, from December 2011, now in April end 2024, there is no order passed by the court, because on the last occasion when the matter was listed for motion, only one occasion it was listed, that was on 9th of July. The petitioner took time. What will you do? You do not know about the petition, whether she is in custody or she was taken into custody and thereafter she was released during the COVID period. Nothing else is there.
I'll have to get instruction, because
What kind of instructions you will get, Mr. Payeng? You have been, I'm not telling you, Mr. Payeng, but
Yes.
the concerned
no, my lord,
department, the
the
conduct of the department appears is not willing.
department has, my lord, only the does whatever is
See,
there.
once somebody has been declared to be a foreigner, you know what is to be done.
Yes, my lord. He has to be detained and deported. That is
When
the-
this writ petition was filed in 2020, there is no mention that she has been taken into custody, but the order was passed in December 2011.
yes.
That itself indicates.
So
See, why should these division benches spend time here? When the department, if it is not willing, let us finish it off.
The department is taking action, my lord, whatever.
What kind of
it-
action will you able to tell us?
Yes, my lord, I'll get, my lord, those who has not been detected, my lord, after declaration, against them, I have, my lord, informed last occasion also, cases have been registered, they're trying to be, my lord, the department is trying to pick them up. my lord.
See, it is up to the home department to detain someone. It is not that we are directing.
No, that is true, my lord. That
Right,
is
or
the-
as not because we are asking that
Yes.
inaction on the home department from tomorrow onwards, the home department will go on arresting somebody or declaring. That is not the case. You see, what we have seen, not is only this case, or not in the case in the morning we have seen, but we have seen the attitude of the home department.
Initially, my lord, everybody was detained, almost every person. Then due to COVID, my lord,
See, there was no COVID in
Yes.
2020, the early part,
earlier part, my lord,
but
then
this particular petitioner was declared foreigner in December
2011,
2011.
my lord. During that time, they were detained, my lord. Whoever.
The petitioner was not detained.
Yes, my lord,
There
probably
is
she was
no
not detained.
submission that she was detained in
Yes, madam.
custody.
Probably
She
she
was
was
in
hiding
detention
her,
camp.
probably she was hiding herself, my lord. So she could not be detained at that time. Otherwise, those every matter possible actions
Her
were
name
taken.
was figured in the voter list of 1966, my lord. Again, my lord, her name was figured in the,
But Mr.
oh, yes, my lord, there is a fault.
This kind of, you see, who is entitled to get benefit under the law? Who is entitled?
Petitioner.
Anybody can come to court and seek relief. She appeared in the tribunal in 2007. She did not file her written statement. And ultimately, the tribunal had to pass that order in 2011 December. In 2020, she appears before the court because in the NRC, her name was not there.
And her name was there. In draft list, her name was
No,
there.
that is in
Her,
the
her
second
name
draft,
along with her son.
in the second draft, when the name was
Yes.
not there, she ran to the court.
Yes, yes.
Do you think this is
Her
entitled for
son
any
name
relief
is
from
also
this
there.
law? As a court officer, with your experience in the bar, Mr. Dasgupta, kindly tell us whether these kind of petitioners are entitled for any relief. As you're standing in the
This is
bar,
an unfortunate.
not as a counsel for the petitioner, but as a court officer, kindly tell us, looking at her conduct.
Actually, my lord, what happened, she is a illiterate person, my lord. Actually,
See, illiterate, whatever.
once he engaged a lawyer, thereafter, my lord,
See, the Furnace Tribunals Act or Furnace Tribunals orders, as you know, is very 1964 order. It is unless and until the tribunal grants bail, the proceeding is required to appear on every date before the tribunal.
yes, yes, that is correct, my lord.
But after taking time, after the petitioner appeared before the tribunal,
Yes, my lord, that's the fault on our part.
you cannot say fault. That's the mockery of judiciary. Anybody can come to this court of law and get an order. Is it possible after this kind of conduct? And you see, as soon as her name was not there in the NRC, she ran to the High Court. Of course, as per the advice of the council.
Yes. Her son's name also
So she
figured.
was waiting, if her name would have been declared in the NRC, what would have happened to this proceeding?
Because she was a voter of 1966.
That could have been
Degrees of
placed. That's sufficient enough. That could have been placed before the tribunal.
And yes, 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 that is correct. Yeah. Her son's name also figured in the NRC. She has been left out of that. In the final list also her son name is that.
No, that thing, the NRC has not yet been published.
Yes, yes, that is true. They were under impression, probably rightly or wrongly, that nothing would happen. Because as when our name is in the voter list, probably that was the impression with them.
Yes, Mr. Payam, what do you suggest? Tell us, what do you suggest?
First of all, my lord, let me get the instruction whether she is.
No,
where
about
she
this
is.
case, forget that you will detain her and put her in
No, 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 that
custody
is
now?
not the, my lord, whether she is there, where she is there. And secondly, my lord, for the conduct, I always submit, my lord. It is
She's already 73 years old.
yes, only from this, they approach the honorable court when they are, only after the, my lord, NRC process is initiated. Prior to that, nobody was, my lord, caring about the procedures. Whatever is there, my lord, nobody was. Only
Why-
when their
why?
name,
Why? Tell us why. What is the reason? Inaction on the part of the Home Department. That's the reason.
in some cases, my lord, it can be, but the
It's not
department.
that if they are regularly appearing in the voter list, their names appear, their family is there, have filed applications to fill up their names in the NRC. They are readily available in that particular place.
Yes,
They are able.
But there are after the orders of the tribunal, Home Department did not take any action.
But after 2012-15, my lord, the department has taken lots of steps, my lord. So only after 2015, my lord, the entire process has taken some, my lord, more move. Otherwise, prior to that, almost 10-15 years, it was, my lord, like that. So after
How many
2015,
foreigners have been taken back by the Bangladesh? Will you able to tell us? After the orders of the court, either from the High Court or from the Supreme Court affirming such decision of the tribunal, how many such foreigners have been taken back?
that is up to central government, but that is not our jurisdiction. We cannot say. So whatever is there, numbers I have, my lord, I can provide it. Some few numbers are there definitely, but it is not that we expect it, my lord.
Mr. Dasgupta, how will you overcome the time period in this writ petition?
that is the problem with me, undoubtedly, my lord. But this is an unfortunate case.
No. This is not only one case.
Yes, I
Thing
don't
is,
know. Like I
these are
said,
happening. That's why I've been interacting with Mr. Payang. We have been seeing this case. That is the reason we're asking you how the petitioner will overcome.
that is an unfortunate case, my lord. Our son's name also figured in the
And then,
NRC, and she was
that is
elected voter
that is
list
why
in
we
the
ask
young.
you, now, which provision of laws you will get the relief?
She along with,
Equitable relief, if they are equitable relief or any relief under the certiorari, if it is there, you know very well the outcome of this writ petition. But Mr. Ridas Gupta, Lanet Senior Counsel, assisted by MS Das Counsel appearing for the petitioner. Also heard.
or you should make, kindly allow me to give some time to file an application.
Mr. J. Payang, Standing Counsel from Department Assam for the response number 2. AIL Standing Counsel Election Commissioner in 2 and 2 and 6. AIL Standing Counsel Election Commissioner for the response number 3. And Mr. P. Sharma, Additional Senior Government Advocate Assam for the response number 5. In a proceeding under the Foreigners Act 1946, being FTU Dinbecket D, case number 438 of
My
2007.
lord, her father's name, sorry.
Doesn't matter. The petitioner, though appeared before the tribunal on receipt of the notice, appeared to the tribunal on 18/12/2007 on receipt of notice and sought time to file her written statement of reply. But thereafter she did not appear before the tribunal on the dates fixed. As such, The Learned Furnace Tribunal, first Morigaon, Assam. By its order, it is 19/12/2011 in Sachin School's number. Considering that the petitioner failed to prove her citizenship as required under Section 9 of the Foreign Act 1946, declared her to be a foreigner under the Foreign Act 1946, illegally entered into territory of India in Wicket, Assam, from the specified territory of Bangladesh on or after 25/03/19. As the petitioner's name did not appear in the second draft NRC of Assam, she on 28/02/2020 filed this writ petition challenging the said order dated 19/12/2011 passed by the Foreign Tribunal, first Morigaon, in said FTD case number 438 of 2007 against her. Call for the records of FTD case number 438 of 2007, disposed of for 19/12/2011 from the Foreign Tribunal, first Morigaon. List on 28th of May. A copy of this order be furnished to Mr. J. Paying, standing counsel on the part for his necessary use, so that he can intimate the Foreign Tribunal the relevant reports.
Much of that.
Please, your lordship.
This writ petition is against the order / opinion dated 30/09/2019 passed by Learned Foreigners Tribunal, second Nagaon, in FT case number 560/2011, whereby the petitioner has been declared to be a foreigner under the Foreigners Act 1946 of post 1971 stream. On 04/09/2020, the court called for the records of said FT case number 560/2011 from said Foreigners Tribunal, second Nagaon. However, office note dated 24/04/2024 discloses that is records of the said Foreign Tribunal is yet to be received by the registry. Surul. Sections. Appear before Superintendent of Police Boda. Walpura. Sorry, Nagaon. On or before 17th May. Right. Biometrics not to leave. It's a reminder for the records of such and such. Please this matter for hearing after the record. A failure on the part of it occurred. Reminder to the foreigners traveler. Second knockout. Kochua knockout. Kochua is a new district. Failure on the part of the authorities in the foreigners travel number. Second knockout. To provide the records of said such and such. Court shall consider to cause consequential or the daring officials. Is obstructing the identification of say of this reputation.
Much.
Take steps on the respondents. On or before Wednesday.
Make this. My lord, petitioner declared foreigner post 1971, my lord. Impugned on page 67, my lord. During trial, my lord, petitioner exhibited one cell deed of
Came of
1963, my lord. Lordship may once may come to lordship case 42, my lord. Lordship may come to
okay.
Let's take 42 is the investigation, my lord, whereby the superintendent of police border, my lord, directed to inquiry against this present petitioner, my lord.
Order
If lordship may
0501/2024. In case number MFT within bracket J2024/2405. No. In case number FT 449/2023. The reference being made by the Superintendent of Police Border Moregaon on the foreigner. As to whether the petitioner is a foreigner. The foreigners tribunal picked Moregaon by its order dated 050 after hearing the party and the point. Petitioner to be a foreigner under the Foreign Act 1946. Who had illegally entered territory of India from the specified territory on or after 25/03/1970. Hence this. Rule returnable by super steps in 2 days from appear before Superintendent of Police Border Moregaon on or before 17.
within
Along with the certificate. Along with certificate. Take steps. Appear before the SP Border Moregaon on or before 17.
on, my lord. Date, my lord.
17th.
Bless, my lord.
Call for records quickly. Notice in this case was issued on 31/05. Interim protection, interim bail, 31/05. Pursuant to the order dated 31/05/2017. Registry have already received the relevant records from the Foreigners Tribunal. Relevant record. Shall appear before the Superintendent of Police, Border Shivsagar. On or before. You appear before the SP Border Shivsagar. On 22nd of May. Along with the certified copy of this order. Complied with the bail order. Subject to the compliance. On its such appearance, biometrics, IDs, fingerprints shall not leave the jurisdiction of the Superintendent of Police without step on the response for hearing. Issue rule. Notice in this case was issued on 9/6/2007. Not very clear. On or before 22nd April. Superintendent of Police Border to biometrics, iris, fingerprints shall not leave the jurisdiction. Interim protection, interim bail, 9/6/2007. Subject to the compliance of the record. Please this matter for hearing. Similar order, 14/6/2017. Interim protection, interim bail, 14/6/2017. Biometrics. Same date. Shall not leave. Already over. Step should include this.
May I please your lordship, matter may be possible for the day lordship.
Notice in this case was issued on 12/06/2017. Appear before Superintendent of Police Border. No problem. Interim protection, interim bail, same day, 12/6. For biometrics, iris, 22nd. Shall not leave. Rule for replay. Hearing.
Chocolate.
Please, your lordship.
Notice 16/6/2017, interim protection, interim bail. For capturing biometrics, iris, fingerprints. Appear before Superintendent of Police Border, Ojai, on or before 22nd. Shall not leave. Rule steps, hearing. Mr. Ratia asked the petitioner to appear before the Superintendent of Police Border, Ojai.
Ojai,
For 22nd.
dispose the matter, my lord.
We are issuing rule. But
No, he is appearing, my lord. Every date he is appearing.
why is appearing? It is not required. Only once he is required to appear.
But as per information, he is appearing.
Will appear this
My lord,
time.
can I have
We have
the,
clarified.
can I have the inquiry report of the inquiry officer and the reference copy of the SP, my lord?
That we apply before the Superintendent of Police Border, Ojai.
Record is here, my lord.
They will have a copy.
If necessary, my lord, I will apply.
When the matter will taken
For
up for hearing,
certificate.
you go to the records at that time and make your submission.
Always.
That will do. 19/6/2017, notice, including protection, interim bail. Superintendent of Police Border, Nolbari. Foreigners Tribunal, 3rd, Nolbari, Mukalma. For biometrics. To appear before the Superintendent of Police Border, Nolbari, on or before 22nd. Right. Yeah. Steps.
Okay. May I please, your lordship, kindly pass out over time. My senior is engaging another court.
Notice issued on 28/07/2017. Foreigners Tribunal, 4th, Nolbari at Gograpur.
Order,
To appear before the Superintendent of Police Border, Nolbari, on or before 22nd. Biometrics, fingerprints, iris, not to leave the jurisdiction. Rule is quoted. Flex.
May I please, lordship?
Notice 31/07/2017. Interim protection, interim bail, same date. Foreigners Tribunal, 9th, just a minute. Let's click this up. Same order. Appear before the Superintendent of Police Border, Nagaon, on or before 22nd. Biometrics, iris.
Lordship, we have appeared already. I have already.
For record, for capturing or biometrics and iris.
Lordship, I will be allowed to go to the LCR, lordship.
Okay. We'll go through and the matter will taken up for hearing.
Much obliged, lordship.
I'm on interim.
Notice issued on 31/7/2017. Foreigners Tribunal, Borpeta, 11th, Sorbok. Interim protection, interim bail, 31/07. Appear before Superintendent of Police Border, Borpeta, on or before 22nd. Capturing biometrics, iris, fingerprint, shall not leave the jurisdiction. Right. Take steps on the respondents within 2 days.
My lord, deeply obliged.
Rule. Notice issued on 4/8/2017. Yes. Fairness Tribunal Bongaigaon number 2 Obeyapuri. Superior Police Bongaigaon. To appear before Superior Police Border Bongaigaon on or before 22nd. Biometrics, iris, fingerprint shall not leave. Rule Kuri. Take steps on the respondents.
May I please, my lord, at morning I have made mention, my lord. My file has been misplaced, my lord.
Okay. Lekha. Notice issued on 7/8/2017. Fairness Tribunal, just a minute. Ninth Nogam. Interim bail, interim protection, 7/8/2017. To appear before the Superior Police Border Nogam on or before 22nd. Biometrics, iris, fingerprint shall not leave. Rule, steps. Take steps on the respondents
Okay, my lord. Most obliged.
within 2 days from today. Eleven 8/2017. Fairness Tribunal Chirang. For biometrics and all. To appear before Superior Police Border Chirang, 22nd. Steps on the respondents. Rule Kuri. Hearing. Records.
Not present, sir. That's-
Notice issued on 8/9/2017. Fairness Tribunal number 5, Kamrup Metro, Guwahati. Commissioner of Police, Guwahati City. To appear before Commissioner of Police, Guwahati City. Border day, Commissioner of Police can border likhi. For biometrics, iris, fingerprints shall not leave the jurisdiction. Rule likhi, steps in 2 days from today.
Lots of appearing on
On or before 22nd.
22nd. May I please, my lord? My lord,
Notice 8/9/2017. Fairness Tribunal, Nagaon, Court number 7, Lanka, Hojai. Interim protection, interim bail, 8/9/2017. Capturing of biometric. Alrighty, Baba. To appear before the Superior Police Border, Hojai, on or before 22nd. Rule steps within 2 days. Right.
no placement.
Notice on 11/9/2017. Rule. Interim protection, interim bail, 11/9/2017. Fairness Tribunal number 3rd, Nalbari. Superior Police Border, Nalbari. On or before 22nd for capturing of steps. So what he written the LCR received from them. Notice in this case was issued on 3/11/2007. Rule 6/6. interim protection, interim bail, 03/11/2017. Commissioner of Police, Border, Guwahati. To appear before, ask the petitioner to appear before the Commissioner of Police, Border, Guwahati, on or before 22nd, capturing biometrics and iris fingerprints shall not leave condition given by. Foreigners Tribunal, Kamrup Metro, second one.
All right.
Take step from the respondents. Notice issued on 27/11/2017. Foreigners Tribunal, second, Borpeta. Interim protection, interim bail, 27/11/2007. To appear before the Superintendent of Police, Border, Borpeta, for capturing of biometrics, iris, fingerprints on or before 22/05/2024. But condition not to leave. Bail shall assay. Notice on 22/12/2017. Hmm? 1/12/2007, sorry. Foreigners Tribunal, Post Nalbari, Khokrapar, Adcock. Interim protection, interim bail, 1/12/2017. For biometrics, that is to appear before the Superintendent of Police, Border, Nalbari, on or before 22nd. Market condition, rules will be. Steps will include it. Before BK Sharma appear kरेगा नाम to BK Sharma दिखो notice issued on 6/12/2007 interim protection interim bail same date Foreigners Tribunal number 3 Nalbari to appear before Superintendent of Police Border Nalbari for capturing of biometrics iris fingerprints on or before 22nd. Steps would include it. Written the records. Records for both. Say to our order. MSP does. Notice issued on 11/12/2017. Superintendent of Police Border Nagaon. Foreigners Tribunal, second Nagaon. To appear before the Superintendent of Police Border Nagaon on or before 22nd. Biometrics. Not to leave the jurisdiction for hearing.
Obliged Lordship.
Notice on 13/12/2017. Foreigners Tribunal, Borpeta, 10. Superintendent of Police Border, Or- Mr. Sharma,
Not.
the matter is from
Then Bozali Patra.
no. Borpeta 10. But the proceeding is from Baksa.
Yes, Dr. I will inform Lord.
It has to go to Superintendent Police Border Baksa, I believe. Or Bozali Patsala.
Some matters has already transferred Lordship. So
Baksa.
concern jury, so I have to take instruction Lordship. Eh, this matter was sent or not Lordship. This record.
By you. That's a lot of it's hard file. 9. Huh?
Earlier Lordship, they also taken to SP Baksa also Lordship. So I think Lordship, it is a Baksa Lordship.
Foreigner tribunal 10 Bozali Patsala. 10 Borpeta Likipa at Bozali Patsala. But nowadays there is a foreigners tribunal at Baksa.
Yes.
Itu লিখিব দরকার নেই আমার foreigners tribunal contact আছে Superintendent Police Border Baksa.
If necessary Lordship, I can take the instruction.
Not required. For recording of these biometrics. Bakuri ruler. 13/12/2017. Huh? Yes, Islam. Notice on 13/12/2007. Okay. Foreigners tribunal 10 Borpeta at Bozali Patsala. Superintendent Police Baksa. Kalgasia is in now Baksa or in Borpeta. Some part is in
Kolkata, somebody in Barbada, Lordship. Kolkata.
Huh?
Right.
Right, vote of the group. Government group.
Trivandrum Police Border Board. For next Tribunal, Bopeta Din, Bojan records. Appear before Superintendent Police Border, Borpeta honor before 22nd for capturing your biometrics.
Lordship, there is a problem, Lordship, we have misplaced this case during shifting of our chamber, Lordship. So sometime extra may be given.
22nd May is sufficient time.
Much of
My pleasure, Lordship. This matter vacantly fixed for hearing, Lordship.
Notice in this case was issued on 13/12/2017. And by order, the 20/02/2020 matter has been admitted. Appear before Superintendent interim protection interim bail. 13/12/2017. Fairness Tribunal. Number 8 to brief. To appear before the Superintendent Police Board to pre-honor before 22nd for capturing of biometrics, iris, fingerprints, not to leave the jurisdiction. Release this matter for hearing on a date to be fixed by the registry. Records be written.
I'm obliged.
Notice issued on 13/12/2017. Interim protection, interim bail, 13/12/2017. Foreigners Tribunal 9 to break. Appear before Superintendent Police Board Dhubri honor before 22nd for capturing of biometrics. Shall not leave. Rule hearing. Written the records.
22nd May, my lord.
22nd of May, honor
Right.
before.
Obliged.
Notice on 12/01/2018. Foreigners Tribunal Jorhat. Superintendent Police Border Sibsagar. Interim protection, interim bill 12/01/2018. Same capturing of biometrics. Rule. Notice 12/01/2018. What's your good name?
P. Sutia, Pooja Sutia.
Foreigners Tribunal Chirang. Superintendent of Police Board, Chirang. Petitioner shall appear before the Superintendent of Police Board, Chirang, on or before 22nd for capturing his biometrics. Makin take a release of in the records.
Please, Lordship.
What's your good name?
Amit Soikia, Lordship. Amit Soikia.
Notice 1901-2018. Interim protection, interim bail. 1901-2018. Fairness Tribunal, Jorhat. Superintendent of Police Border, Sibsagar. Ask the petitioner to appear before the Superintendent of Police Border, Sibsagar, on or before 22nd, capturing his biometrics.
Lordship.
Right.
Deeply applaud.
Notice 1901-2018. Fairness Tribunal, Kamrup Metro number 1 over 8. Commissioner of Police Border, Guwahati City. Same rules of replay. 22nd of May. Capturing compartment. Shall not leave. Take it. Return the record. Heard Mr. Idas Gupta, and senior police, assisted by MS. Notice in this case was issued on 3101-2018. Interim protection, interim bail, 3101-2018. Superintendent of Police Border, Nagaon. A Fairness Tribunal 9th, Nagaon. Rule returnable take. Mr. Dasgupta asked the petitioner to appear before the Superintendent of Police Border, Nagaon, on or before 22nd for capturing his biometrics.
27th May.
20 on or before 22nd of May. For hearing on a date to be fixed by the list. Come back at 2.
I am sorry, my lord.
It's okay. How many additional affidavits you have filed?
My lord, I filed 2 additional affidavits.
Is it possible to develop your case like that
And because my
without
lord,
placing it before the tribunal?
that is, your lordship earlier, this matter heard. And a proposal has been made to file approach there, to filing those all documents. So since there is a long time, now they may not be considered it. Because my lord, my brother, case has been registered against them also. And they were declared Indian.
Which paragraph of your written statement you have said that you have a brother?
Now the written statement is very blank.
Where you have stated?
Not stated. My lord.
You have not stated.
My lord, your lordship kindly stated paragraph.
Written statement.
Yes, my lord, written statement.
Which paragraph?
Yes, 12, my lord.
What you have stated?
Here he has not stated anything regarding his brother, but in examination, see, cross examination, he stated.
Cross-examination, whatever you might have said, without, if it is not available in the written statement, can be considered. What is the law laid down by the Honorable Apex Court in this regard?
It is in like a civil case or other case, it should be mentioned.
What is the law?
It is mentioned.
What is the law? That's why you're
It is to
asking
be
me.
stated in the written statement. But as per decision of our this honorable court, it is not necessary because this proceeding is completely different. That is why that can be considered.
So,
yeah, that can be considered here. In a hydrological case, it has been law has been laid down.
so considered, you can bring anything, any material without placing it before the tribunal for the first time. Can you bring it to the High Court?
Because
what is the law laid down by the Honorable Supreme Court? Very recently passed judgment.
It is they should mention all the facts in the trial court. In the affidavit, they should file. If they could not file anything later on discovered, they should be filed there. Under order 27.
Such proceeding who is suspected to be a foreigner becomes wiser day by day, and when they are more tangled with the learned counsels, the lawyers, they become more wiser. Sometimes more wiser than the lawyers. In the written reply, there is no mention.
No mention, nothing.
Because written reply and the evidence in affidavit are filed within a short period. So in the evidence and affidavit, the proceeding becomes more wiser. He adds few things. When the judgment is delivered, saying that the person is a foreigner, he comes to the High Court. There he meets separate sets of counsel, which are much more wiser than the counsels in the district level. There they give certain, they include courage in the writ petition. And also by a good kind of submission, they get a chance from to file additional affidavit, right? Now, day by day becomes more wiser.
But
in the affidavit filed by the proceedee here, there is no mention, first of all, the place of birth of the petition. There is no mention when his parents or he himself has shifted from one place to the other. Now see how he has become wiser. The later part he became that he has brothers and sister. But interestingly, he doesn't know the name of the husband, his brother-in-law, nor his sister-in-law. How will he know? Very well, pick up one affidavit, pick up one voter list from this place, pick up that voter list from that place. And that is why their names, if in the voter list, the name of their wives would have been there, he would have been wiser. He said, yes, these are the names. But in the voter list, names of those brothers, wives of their brothers and sisters are not there. So he said, I do not know the name of the sister-in-law, no, know the name of the brother-in-law. Very good.
But I found two voter lists, and their brother's name appeared along with their.
Only because Mr. A is the father of the petitioner, and also become there is another A in another village. Both have become brothers.
Cross-examination, someday, somewhere he.
Cross-examination, whatever you might like to say, or in evidence, what like to say, if it is not there in your
Yes.
written reply.
My lord, earlier, Your Lordship's order, Your Lordship earlier heard this matter 2 days, very beginning. But Your Lordship has proposed me to go there and file all this thing there. Ultimately, this matter was not listed. Your Lordship heard this matter in full, and in 2 days, Your Lordship heard this matter. And it was also kept part heard with that suggestion. But later on, the matter was not
These
listed.
things are different from the reading of this. Come to page number, will you able to read page 14? Okay, come to page number 12. This is the basis, right?
Yes, sir.
Kindly read page number 12.
I have gone, my lord, nothing, my lord, nothing. I have gone through it.
See, normally.
But only paragraph 3 he stated.
See, everyone here,
My lord,
the basis, we are all lawyers at one point.
my lord.
The person who has written this written statement for the petitioner, he would have written everything, whatever information the proceeding could have given to you. The proceeding doesn't know anything. That is the knowledge of the proceeding which is required to be given to the concerned lawyer so that he can incorporate it in his written reply. Since the proceeding was not at all aware of all these facts, the concerned counsel, whatever is that he has given. Now later on,
Well, sometime, my lord, lawyers has committed also mistake. This type of affidavit, this type of written statement
see, if
should not be filed.
something is there, if something is there, it could have been brought immediately before the tribunal,
Yes.
right? The proceeding is not at all aware of all
Yeah,
this.
my lord.
Proceeding doesn't know the name of his own brothers. Proceeding doesn't know name of his own sister. Proceeding doesn't know his brother-in-law. A brother-in-law of a single sister is very precious,
My lord.
right? Very close, just like a friend. So,
Otherwise,
where is the illegality? Whatever
no,
materials
no
is
legality. There is no legality, my lord.
in the order, there is no illegality.
I found no legality because I could not only cross-examination law consider it. Then my lord.
Mr. Payang, and that is why all the judges like Mr. Jasimuddin Ahmed.
Hello.
Not from today, what we have seen while entering the court as the president. Even the senior judges earlier, it's always like him. He is very fair. And really, I do also appreciate he is very fair. If he has a certain point, he will say that I have only this point, nothing else. Today also he said he is very fair. Yes. Since you have brought it to the notice of the court, let us see the voter list.
My lord.
See, you say that for the first time you have your name figured in the voter list in the 1997.
Yes.
What was your age on 1997?
In 1993 also his name appeared, but
No, 1997, what was your age?
1997. Yeah, this one. 45, my lord.
Okay. Now, in the writ petition, you have also annexed the voter list of 1983, right? Now, if it is-
1993.
Now, if India 1997, you are 45 years old.
In 1993,
Which
33.
will be your birth year? So 1952 will be your birth year.
Yes, my lord.
If it is 1952, when you are eligible to vote?
70. 70.
73.
73.
Right?
Yes.
Now, this 1997 voter list, 1970 voter list of your father
Yes,
and 1965 voter list of your father.
father.
What is the link? Where is the link?
In voter list, there is no link. Voter list, my lord, not jointly appear.
Then
my lord.
how you are going
But
to?
in 70, my lord,
Hmm.
in 70 voter list,
Hmm.
my father
Hmm.
name appeared,
Hmm.
Muslim Uddin.
Okay.
This is the only link, my lord. I filed an additional affidavit that Muslim person was also drawn
Hmm.
against that Muslim Uddin. He was declared as Indian.
Fine. That
But he
Muslim
was residing in Sengajan. After marriage, I shifted from Sengajan to President
Hmm.
Bokanola. They remained there in the
When
original
did your
place.
parents live at Sengajan?
It may be after 65, my lord, they
Where you have stated that?
written statement, nothing has been mentioned. my lord.
So,
But
because you see, in 1965, you are 13 years old. It is not that nothing was not
Mind
to your knowledge. If you consider 97 voter list as 45 years old, then in 1965, you are 13 years old. And 13 years old is sufficient to have the knowledge. So, here the procedure doesn't know when his
He-
parents shifted from,
but he did not disclose it before the
up to him,
Yeah, my lord.
right?
But he know.
Now, if
Then
it is from Sengajan
Sengajan.
in 1970,
No, no.
right? When did the petitioner shifted from Sengajan to Dobokanola?
Sometimes before 1983, he was he shifted.
Should be truthful.
And there are communal
cannot
rights,
be-
and there is a communal rights in then his father was killed in during the communal rights.
Where is
I
the
think
certificate from the government?
that was not there.
Say anybody dies or anybody is killed during such kind of riot,
But
gets compensation from the government.
Yes,
Where is that certificate?
those are not there. But they
So
mentioned
just make a mention. That's
mention
all.
is a cross
It is
examination.
easy to say,
Yes.
right?
Right.
And Nelly or something, nothing had happened at Doboka or Singajan. It happened only at Nelly. And Nelly, you know, the tribal people expired.
Many people expect that. Many
You have the list. The High Court has a list.
800, more than 8.
High Court has a list.
Yes, yes.
You may not have the list.
Yes.
It's in the Home Department.
Yes.
So
More than 800 people.
you're not talking about the Boruland.
Yes.
The riots at the Boruland are something different.
Yes, different. So my lord, only basis of the fact that his two brothers were declared Indian. So my lord, matter may be remained back. Give a chance
See,
that he
basically,
will lay the evidence
you
before
do
the
not know who is there in your brother, who is your sister. Later on, you have come up. That cannot help you. That is why we are asking you to read this judgment of the
Yeah.
Honorable Apex Court. So, as any such judgment passed by the Honorable Supreme Court, wherein in a Foreigners Act, the Honorable Apex Court allowed the proceedee to file after the judgment passed, file additional affidavit or to bringing certain new fact, unless the said fact could not be placed before the tribunal in spite of your report. The Constitution bench judgment of the apex court with regard to the foreigners tribunal very clearly has stated why it is written reply. Written reply is given a chance to the proceeding to say that he is not a foreigner, so that he or she can place before the tribunal about the fact that he had the knowledge, because that knowledge will not have by anybody else. Only the proceeding will have the knowledge. Now, if the proceeding has grown up to such a year that says in 1985 he was in the voter, and in the 1970 voter list his brother who is 3 years older to him, his name is there, will he not know that he is my brother, sister, father? Definitely, my lord. Anything else? Only link document you want to show that in 1970 voter list one person is there.
Muslimuddin,
So his case has been considered
along with
and his father is same and your father is same. But where is that proof before the tribunal? Same Azimuddin. Where is that proof?
only 1970 voter list only. My elder brother's name appeared along with my parents.
Where you have said that your father has shifted from the village A to village B?
Nowhere.
Then, just see, yes, what the procedure is trying to help. We have seen that let us assume that 1997 you have 45 years, right? Please come to the first additional affidavit that you have filed. You have filed in December 4th. It is at Page 6 is the SMS cross-examination part. We'll read together, right?
Yeah, but
More naam Mohammad Junab Ali, boyoh 65 বছর. So, on
2016. 17 to 2016.
as per this, his birth year is 1946. Pita Azimuddin, ঠিকনা গাঁও ডবকা নলা, ডাক হিন্দু ব্লক, থানা ডবকা জিলা নগাঁও অসম. মোৰ ককা দেউতাৰ নাম স্বৰ্গীয় তনু শেখ. ককা আইতাৰ নাম নাজানো. Forget this is আইতা, should have been. আইতাৰ নাম নাজানো. মই তেওঁলোকক দেখা পোৱা নাছিলো. মোৰ ককা দেউতা ও আইতা ক'ৰ বাসিন্দা আছিল মই নাজানো. মোৰ দেউতা স্বৰ্গীয় আজিমুদ্দিন. তেওঁ 1983 আন্দোলনত ঢুকাল. তেতিয়া তেওঁৰ আনুমানিক বয়স 85 বছৰ আছিল. In the year 1983 he expired, and at that point of time his age was 1985. That means his birth year was 1902. মোৰ মাৰ নাম স্বৰ্গীয়া মালেকা বানু. মোৰ বয়স 15-16 বছৰ থাকোতে তেওঁৰ মৃত্যু হৈছিল. So let us assume you were born in 1946 and let us have the maximum be 16. So in the year 1962 your mother expired. Now interesting part is in the voter list of 1970 your father was there, your mother was there. In the voter list of 1970, that which you have annexed,
Yes.
to prove
I
your
have
link, right?
Yes.
How old was your father?
But I made this query to my client.
Your father
He
was
said-
1940,
Yes.
you are 46 years,
Yes.
and your mother was 45 years.
I made this query to my clients that he said that 85 years, it had been wrongly written, it should be 65 years, he said.
Now you can go on doing calculations, Mr. Jasimuddin Ahmed. That will help you or worsen the condition of the petitioner you do not know at this stage. তেওঁৰ মৃত্যু হৈছিল. তেতিয়া তেওঁৰ বয়স 50 বছৰ আছিল.
Yes.
Now how are you going to rectify this mistake?
Yes.
In the year 1960 she was 62, she was 50 years old. Then how come in the 1970s she is 45 years old? Now rectify this mistake.
No.
মোৰ দেউতা মোৰ ককা দেউতা একমাত্ৰ সন্তান আছিল. মোৰ দেউতা গাঁও চেঙাজান, থানা কামপুৰ, ৰহা বিধানসভা সমষ্টিৰ বাসিন্দা আছিল. মোৰ দেউতাৰ নামত কোনো মাটি জমি নাছিল. মোৰ জন্মও চেঙাজানত হৈছিল. মোৰ পঢ়া শুনা নাই. 1983 চনৰ আগতে মই চেঙাজানতে আছিলো. মই ককাই ভাই ভনী 4জন. 1 নম্বৰজনৰ নাম মুছলিমউদ্দিন, 75 বছৰ. তেওঁৰ পত্নীৰ নাম মই নাজানো. 2 নম্বৰ মই আৰু মোৰ পত্নীৰ নাম মোছাম্মদ জামিলা বেগম. 3 নম্বৰ মোৰ ভণ্টি নাম ফুলবানু আৰু 4 নম্বৰ মহম্মদ ইউসুফ আলী 47 বছৰ. পত্নীৰ নাম মই নাজানো. মোৰ বিয়া 1981 চনত ডবকা নালা হিন্দু ব্লক নিবাসী নেমাজী আলী পুত্ৰী মাছ জমিলা বেগমৰ লগত হৈছিল. মোৰ ল'ৰা 2জন, ডাঙৰজনৰ নাম ইমান আবুল হুছেইন বয়স 40 বছৰ আৰু সৰুজনৰ নাম আবুল হাকিম বয়স 33 বছৰ. তেওঁলোক মোৰ লগতে থাকে. Right? Now just tell us which voter list to be considered to link you with your father. You said that prior to 1983, you were at Sengajan. And by that time, Muslimuddin got married, and you do not know your name of your sister. if it is in 1983, show us any voter list where the name of Muslimuddin and you exist together. That is why Honorable Apex Court has clearly stated that when these cases, the foreigners tribunals, foreigners issues are there, the evidence has to be reliable, truthful, and acceptable. In 1965 itself, the Honorable Apex Court, the Constitution Bench has said that. Why?
Panduran case.
Why it said that evidence has to be reliable, truthful, and acceptable? Now, to make this cross objection that you have said, from here just tell us which is reliable and truthful to be considered as acceptable.
Correct, my lord. But in additional affidavit, my lord.
Whatever you link it, that is why we are linking all the documents that you have placed. What are the voter list with your brother or your younger brother, wherever?
If it was kindly low, my
Show us
addition.
any voter list. Your father expired in India in 1983. After 1970, show us any voter list of your father. That should have been along with you in 1983 at the Sangazan. Why it is not there?
But if you also kindly see my second additional affidavit. For a moment.
Sure, why not?
Page 5.
Hmm.
This is the voter list of 1985. For the first time, the name of the petitioner appeared.
When did you shift?
After shifting.
Where?
Doboganola.
So you married someone from Dobokandala and we stayed there at Dobokandala.
I married Doboganola and I stayed.
Why your name did not figure prior to 1985 in the voter list?
It is not there.
It should have been listed along with your father.
But
at least from 1971, your name should have been in the voter list along with your father.
But in that voter list, his age was recorded as 31 years.
That is why I say, if it is 31, then you are eligible to vote in the year when you are 21 years old. So in the year 1975, you are eligible to vote. That means your father expired in 1983. From 75 to 83, 3 elections took place. Why your name is not there along with your father?
And other voter list.
Explanation, Mr.
Other voter list, my lord, regarding my brother. I found that all are separated. Separate house number is there. So that is why their name not appear in the along with the father. Page 7 also, my lord, is one.
Where you have stated that you are separated from your brothers while your father was alive at Sangajan.
It is not written, but he said that after marriage
So,
he was.
see, that
he
is the reason the Apex Court have said the evidence has to be reliable and truthful and acceptable. Yes, Mr. Payang, the same thing has been adopted by our High Court, by coordinate bench in many cases, clarifying the evidence of the proceeding under the Foreigners Act. What are those judgments?
First of all, Mother, this is judgment. WPC Mano 3071 2016. 307 2016, Mano. It is Joinaluddin. And it
JOY or JAI?
JAI, man. JAINALUDDIN. Joinaluddin versus Union of India.
When was disposed of?
Disposed of 3/4/2018, man. 03/04/2018.
Oh, no. Because of the 3/4. This was of the color.
They're in page number 3, my lord. Two 2006.
Yes, where?
My lord, may kindly see page number 2 onwards, my lord. 2 last line, last. They relied on my lord Sarbananda Sonowal. Why, my lord, the good and sound reason for placing the burden of proof upon the person concerned who asserts to be citizen of India of particular country. In order to establish one's citizenship, normally he may require to give evidence of his date of birth, place of birth, name of his parents, the place of birth, and citizenship. These are the material facts, my lord, which they have to be pleaded, has to be pleaded at the time of my lord the written statement. That is the, my lord, facts. Now, my lord, in the below, this court has held its sovereign decision that when the citizenship status of the proceeding is questioned, dead to by the state, it is the burden of the bounden duty of the proceeding to disclose all material facts in his possession at the first instance itself. Not whether it is WS or whether it is written reply, but in the first instance itself. It has to be disclosed in the first instance itself. And what are the material facts? These material facts: date of birth, place of birth, names of parents, their place of birth, and citizenship. All this has to be pleaded in the first instance. In this case, in the written statement. In this case, in the written statement. Where my written statement is there, that written in the written statement, it has to be given. Failure to disclose material facts in the written statement by itself may lead to a drawal of adverse presumption against the proceeding. However, mere pleading of material facts in written statement is not enough. Once pleaded, that has to be proved. If material facts are disclosed, those would then have to be proved by adducing cogent, reliable, and admissible evidence. This is the only basic need, my lord, in all the cases, not only these cases, all the cases. Now, what are the material facts, my lord, we have come to know already? Now, what if he has pleaded in the first instances? In the written statement, he has not stated anything about his year of birth, which is a material facts as per the Sarbananda Sonowal itself, my lord, his date of birth. We are not saying date of birth. At least the place of, my lord, year of birth, or during this period. He has not stated anywhere that during 1950 or during 51, no, whatever may be, my lord, some instances, at least, that pleading is not there, not even the year. Secondly, the place of birth. He has not stated anything about it in his written statement. Nothing stated about his father, about his parents and grandparents. No statement of any siblings, if any, because he has claiming now, my learned senior friend is claiming that his brothers have been declared Indian, so he may be declared Indian, or he may be given that opportunity. My lord, he has not pleaded a single words that he has a brother or sister in the WS, and that they have cases pending in any other tribunal. There is no statement. Even during the time of my lord cross-examination, even though he has stated he has brothers and sisters, he has not stated that his brothers or sisters has cases pending in the my lord tribunal, and their cases are also going on. He has not stated, or they have been declared Indian. He has not stated. Now, when they have been, one person has been declared for Indian, to get benefit of that opinion, he is claiming here that he is my brother, so he has been declared Indian. I may be given the same opportunity, or I may be given the same benefit. How can it be? He has not pleaded anything in the WS, nor in the my lord evidence. He has also not explained about when did parents died. Only in my lord written, only in evidence when cross-examination, he has said during 1983, father died, mother died. Why his name was not recorded during prior to 1997 in any documents, my lord, not only in voter list, in any other government documents. Why his name was not there prior to 1997? That is not there. Why his name was not recorded with parents during Manot? He as per the Manot, if we calculate, he was eligible to vote in 1971 itself. From 71 to 83, even though we accept that his father died in 1983, 77 voter lists could have been produced, my lord. The 77 voter list is available. 75 voter lists could have been produced. Those were not proved. And there is no explanation why his name was not recorded along with parents. Not a single explanation. And there is no statement about shifting of his place in the WS. Even in written evidence in affidavit also, he has not stated anything. Only in cross-examination, he has given some explanation, but that is also very vague. And if we go to the written evidence, the cross-examination part also, as your lordship has already seen the additional affidavit, your lordship has pointed out whatever pointed out. That apart, one more thing your lordship will find. One more thing, my lord, that he has stated that his mother died when he was 15, 16 years old. As your lordship, and if we calculate, if the petitioner was born in 1950 also, because he was 65 years in 2016, 17, 16. So it will be 50, 51 sometime, my lord. We have to presume that 50, 51. Then it will be sometime in 1964, 65 or 66 maximum. But in 66, 65 voter list, mother name is not there. But in 70 voter list, after the death of the mother, her name is appearing in the voter list. When she was alive, her name was not there. When she died, thereafter, her name is appearing in the voter list in 1970. So this is what my mother, even though my understanding is, the tribunal has rightly discussed everything in the opinion, or think whatever is there, everything has been discussed. And my understanding is that, my lord, the petitioner has no knowledge anything about these persons whom he is claiming as his parent. Petitioner has no knowledge anything about the original person whom he is claiming as her parent. He has picked up these documents and trying to build a story, my lord. And now the original, whatever was original, he has deposed that one. That's why everything is not mismatched. Probably her mother was there who died when he was 15, 16 years old. That was right. And that is not matching with the present story, the documents, whatever he produced. Because he is not the original person. That is not the person whose name is there in the voter list. They are not the original person or original parents of the petition. So that's why it's not matching. Everything is mismatched. If whatever he stated is correct in cross-examination, then whatever submitted in the documents, whatever submitted are not correct. So his father was, as per him, when the father died, he was 85 years. It cannot be. Actually, probably his father was 85 years when father died in 1983. But he is not these persons whose names are in the voter list in 1965 and 70. That's why the ages are not matching. And moreover, the grandfather's name, even though he has not stated anywhere, the record, there is a noting in my note, in the record, piece 25. The grandfather name he has said is Tanu Sheikh. The voter list of 1965. Probably in the record he has stated his grandfather, piece 25, my lord. He has said it. Tanu Sheikh. He has stated Tanu Sheikh. But the 65 voter list, if we see, my lord, it is Asu Sheikh. In 65 voter list, it is Osu, the projected grandfather. He has not stated in WS nor in the evidence, but we have to, from record, if we see. And 70 voter list, it is Tanur. So in fact, my learned senior friend also was saying, my lord, there is nothing in the case. What my submission is that, my lord, there is nothing in the case and the tribunal has not committed any wrong. There are other judgments to that, my lord, on WS. Just I'm pointing out 2-3 judgments of this honorable court, my lord. One is 2017, 3 GLJ, my lord, 490. (2017) 3 GLJ 490. Para 12, my lord, it is the proposition. Para 12 and 12, 13 and 14. The principle laid down there is the written statement submitted by notice procedure under Foreigners Act 1946, which Foreigners Order 1964 is a foundation of his or her defense. The written statement is the foundation of defense, madam. Since citizenship of the notice is questioned, the notice should come with all material facts within his or her exclusive knowledge in terms of the section 9 of the Foreigners Act 1946 and disclose them in the written statement. Divertment made in the written statement are thereafter required to be proved by adducing cogent and reliable evidence. This is failure to disclose the material facts will lead to adverse presumption. That is the same proposition. Other judgments are there, my lord. Just I'm pointing out the judgments, my lord. 2017 5 GLR 670, Zahirul Islam, same proposition. Then 2007 5 GLR 670, Zahirul Islam, same proposition, my lord. 2017 2 GLT 1076, my lord.
1076.
Yes, my lord. 2017 2 GLT 1076, Momin Ali versus Union of India. There are the variance between pleadings and proof is not permissible. That point is there. Variance between pleadings and proof. Whatever pleaded in the WS, that has to be proved. The variance between pleading and proof cannot be allowed. It's not allowed. Same proposition is settled in 2017 5 GLR 308, my lord.
GLR 308.
Yes, ma'am. Muhammad Anwara Begum versus Union. So these are in case on WS, my lord. No, my lord, certiorari, your lordship has pointed out already. Under certiorari jurisdiction, how can we examine all these things, even though my learned friend senior friend has filed 2 additional affidavits, and some documents which were not exhibited are brought to this record before this honorable court. How far it is permissible? This is not permissible because this honorable court has clearly said in numbers of cases, in foreigners cases, in fact, has that in the certiorari jurisdiction, this honorable court cannot look new documents in the High Court. That is settled. In fact, that is settled, my lord, by the Supreme Court also. My lord, this is on certiorari jurisdiction 2023, my lord, SCC online, SC 996, as your lordship has, my lord, Central Council for Research in Ayurvedic Science.
Hmm.
In that case, my lord, para 50 onwards, everything is discussed. In which case, my lord, the certiorari jurisdiction, under certiorari jurisdiction, the High Courts can issue writs of certiorari. And it is clearly, my lord, clearly settled that this under certiorari jurisdiction, we cannot review the opinion of the tribunal unless it is, my lord, it is bad in law due to, my lord, the non-consideration of material facts, material evidence which were placed before the tribunal, or consider the immaterial evidence which were not placed. And my lord, if the petitioner is denied of any natural justice, so there is no allegation of denial of any natural justice. The tribunal has not considered any material facts, or tribunal has not, my lord, not denied or not considered the evidence whatever is produced by the petition. So there is, under such conditions, my lord, this honorable court may not interfere the opinion of the tribunal. With regard to, my lord, that this honorable court, to 2023 SCC online SC 996. 9960. Nothing document.
Mr. Ahmed, anything else?
Yes, my lord, I relate to judgment. So can this
Yes.
one to already there, my lord, Hyder paragraph 24, 26, 27, 29, 33, 39, 41, 42, 46.
Just a minute. 24, 26, 27, 29.
29, 33, 39, 41, 42, and 46. All things are discussed in this case, my lord.
Then?
And regarding consideration of new documents, LOC LEC 2001 10 SCC 619.
619.
Paragraph 4.
2011.
2001. 10 SCC. I hand over this one copy.
No, we have. What else?
Here, my lord, as additional evidence, it should be considered. So we will hold that.
Under which provision of law?
It is only regarding CPC.
No.
It is paragraph 4.
The Evidence Act or under this?
My lord, it is paragraph 4. I read it, my lord. It may be pointed out that this court, as long back in 1963, in K. Venkata Ramaya versus Frencho, pointed out that scope of unamended provisions of Order 41 Rule 27C, that though there might well be cases where even though even though the court found that it was able to pronounce the judgment on the state of the records as it was, and so additional evidence could not be required to enable it to pronounce the judgment. It is still considered that in the interest of justice, something which remained obscure should be filed up so that it could pronounce its judgment in a more satisfactory manner. This is entirely for the court to consider at the time of hearing of the appeal on merits, whether looking into the documents which are sought to be filed as additional evidence need be looked into to pronounce its judgment in a more satisfactory manner. If that be so, it is always open to the court to look into the documents and for the purpose of amended provisions of Order 41 Rule 27B CPC can be invoked. So application under Order 41 Rule 27 should have been decided along with the appeal. Had the court found the documents necessary to pronounce the judgment in the appeal in a more satisfactory manner, it would have allowed the same. If not, the same would have been dismissed at that stage. But taking a view on the applications before hearing of the appeal, in our view, would be inappropriate. Further, the reasons given for the dismissal of the application is untenable. The order under silence cannot therefore be sustained. It is accordingly satisfied. The application is restored to file. The High Court will now consider the appeal and the application and decide the matter afresh in accordance with the law. And same thing has been discussed in 2012 8 SCC 148. 2012 8 SCC 148. Union of India versus Ibrahimuddin and others.
What is the proposition there?
Provisions, my lord, regarding same, my lord, this is paragraph 39 to
This in under what?
36 to 49.
Under what? For which purpose you are placing this?
Because this position for additional,
Affidavit.
yeah, additional. But it is more particularly paragraph 49, 46, 47, all the Oh, what is it? Huh? Another machinery.
Do you have a CPC with you? Okay. Take this. What is order 41 rule 27?
27. Production of additional evidence in appellate court.
In
Appellate court.
whether the writ court exercising the power of certiorari is an appellate court to with regard to an order passed by the tribunal.
But yes, it is not appellate court. But this power of this court more than appellate court.
Now, when
Because there is no provision for appeal, there is nothing. This is
So-
the only from to have come against that judgment, the people will come. This is the only from.
Okay.
There is no other from, my lord.
Now, just tell us one thing. When did you file your written statement? On which date? December 2015. 15. Right?
Yes, ma'am.
Where did you file your evidence in affidavit? December 2015.
And for us exam on 2016.
Order was passed on sometime in June 2016. Nineteen 65 voter list you procured December 2015. 1970 voter list you procured sometimes in October 2000, has to be 15. Others are not certified copies. Your cross was on 17th of February 2016. Nineteen 85 voter list you have procured August 2018. Nineteen 97 voter list of your brother you have procured in December 2016. Your other brother
They collected from my brother
collected from your brother.
letter. My brother exhibited that document in his case.
Now, your written evidence in affidavit, where you have stated that you have three brothers, you have 4 siblings, have you stated
In SIP, not,
in chief?
no,
Have you stated that the proceeding against your brothers are going on in the foreigner tribe?
no.
Your second additional affidavit, Mr. Omni. Page number 8. One Muslimuddin, son of Azimuddin, from village Sengajan, 42 years old. What will be his birth year? 1997 minus 42, 1955. Right?
Yes.
Village is Sengajan. Next page 10. Another Muslimuddin, not Muslim, it is Muslim Uddin. Father is Alim Uddin, not Azimuddin. He is from village Dharmukh.
Dharmukh and Sengajan, my lord. Later,
Particularly
in middle part, my lord.
That we have seen.
Dharmukh and Sengajan.
Now, in the year 2011, This Muslim Uddin, not Muslim Uddin, son of Alimuddin, not Azimuddin, is now 67 years. 2011 minus 67. But here is 1954. All different villages. Come to your cross. You have said your elder brother, Muslim Uddin, 75 years.
In 2016.
75 years, while your cross-examination was in February 2016. Do it. How old are you? What is his birth year?
41.
41. See the difference.
No, well, everything I have also gone through the thing, madam.
That is where
It
you
was
would be able to
just I
escape
for
the evidence part.
satisfaction I finished this
But-
documents, madam.
Mr. J. Ahmed, actually appearing.
So I
for
made a
petitioner.
prayer that if it was
Okay,
remand back the matter,
Consider all the just.
yes. Then they will get a chance.
Only one point, my lord, I'd like to point out with regard to the certiorari jurisdiction. So, Lordship, we have, because the tribunal, it is always argued the tribunal in the foreigners order and act, my lord, there is no provision for appellate provision. There is no appellate provision. So, this honorable court has considered that aspect. Your Lordship may kindly see that is in para 112 of the, my lord, the Muslim Mandal. Para 112 Muslim Mandal, my lord. It is so, the larger bench of this honorable court has clearly said what is the jurisdiction of this honorable court. That aspect, so always arguing that, my lord, we don't have appellate authority, so it should be treated as appellate court. That is not. That cannot be. Because this is clearly, this is article, may I read the 112, my lord, only for that purpose. Article 226 of the Constitution confers on the High Court power to issue appropriate writ to any person or authority within its territorial jurisdiction. The tribunal constituted under the Foreigners Act 1946, read with the Order 1964, as noticed above, is required to discharge the quasi-judicial function. This is especially in case of our case. The High Court, therefore, has the power under Article 226 of the Constitution to issue writ of certiorari, quashing the decision of the tribunal in an appropriate case. So this has given, this is clearly said, my lord, that this honorable court has.
My lord,
the,
may I, court number 7, my lord, I have. That I have.
So this is clearly said, my lord, the High Court, therefore, has power under Article 226 of the Constitution to issue writ of certiorari, quashing the decision of the tribunal in an appropriate case. So, what is the, my lord, jurisdiction of this tribunal has clearly said. Under 226 certiorari jurisdiction, this court can, my lord, quash the opinion of the tribunal in an appropriate case. So we cannot go beyond that. And there are discussions. Yes, ma'am.
Anything else?
Everything is discussed there, my lord, under what condition. In fact, my lord, para 112 has clearly said under what condition this honorable court can interfere in the tribunal's opinion. So everything is there on it in para 112.
Okay. J. Pang,
Only one judgment, my lord, I have mailed just now. It is a recent judgment of the Honorable Apex Court, my lord. There it is settled. The same position has been said. My lord, in review jurisdiction, we cannot go. Under my lord, certiorari jurisdiction, the High Court has no power of reviewing the order, the opinion of the tribunal or the subordinates. That is, I have just mailed it.
Print out clearly, do you conduct? Any Council Home Department for the restaurant number 2, 4, and 5, as well as Mr. R. Talukda, Government Advocate Assam for the restaurant number. Arguments complete. Kali reference kita ulang